Hello and welcome back after the summer break to a new episode of the EDPS 20 Talks. As you may already know, in these EDPS 20 Talks, together with our guests, we discuss their unique perspectives on data protection and privacy and how these shape their respective fields. Our next guest is Hellen Mukiri-Smith. She is a lawyer specializing in public and private international law and the regulation of emerging technologies and data. Hellen is a PhD from Tilburg Law School, Tilburg University in the Netherlands. Her research interests include how digital technologies can exploit and exacerbate vulnerabilities and create new vulnerabilities in interactions between users and deployers of these technologies, and the regulation of data and artificial intelligence systems. She works at Amnesty International as a researcher and advisor on artificial intelligence and human rights at the Algorithmic Accountability Lab within Amnesty Tech. Hellen will, I am sure, bring a wealth of knowledge and experience to today's discussion. We are thrilled to have you here with us, Hellen. Hellen, welcome to the EDPS 20 Talks.
Thank you very much for having me.
Let's perhaps start immediately with a question we ask all our guests, just to break the ice a little bit. Hellen, what does privacy mean to you, and how would you apply it in your everyday life?
Thank you for that question. Privacy is usually defined as in terms of private things or private places, the right to a person's individual space, the right to be let alone, one's ability to exercise their autonomy to control when and how and to what extent information about them or us is communicated to others. For my part, when I think about privacy, I think that while these individualized definitions of privacy are very important, it is important to consider or recognize that privacy is relational, that as individuals, we are not self-made atoms, but that we live within and are connected to social networks. And as a result of that, privacy or a sense of autonomy or self-determination cannot be properly achieved by only guarding or eliminating external influences in our lives, but by also creating socially supportive contexts to assist in our autonomous decision making. So for me, I am constantly aware that because I live in a networked environment, I need to exercise privacy management for myself continually, establishing boundaries as I interact with others in different spheres of life, especially through the use of technology. And I am constantly aware that privacy also is a reflection of different tensions, my own goals to interact with my networks, but also my goals to retain my privacy. And another tension that comes up is that the deployers of the technologies that are using these technologies or deploying these technologies are also monitoring my movements. So it's a complex situation where I'm constantly trying to manage my connections with others within my networks, but constantly aware that there are other goals that exist out there by the deployers of these technologies.
Yeah, there are some keywords that you mentioned now: communication to others, boundaries, tensions, monitoring, which brings me to the next question I had for you, and this would be perhaps the other side of the coin with regards to privacy, and this is government surveillance. So this debate on surveillance is as long as the history of personal data and privacy protection. And perhaps the most used argument to justify government surveillance is that surveillance is necessary for public safety. What are your thoughts on that? Can privacy and surveillance coexist?
Yes, that's an interesting question. We are aware, especially in my line of work, advising on human rights and the use of technologies for surveillance purposes and the impact those technologies have on human rights. It's clear that laws that enable government surveillance are often frequently at odds with privacy laws. This is because surveillance laws often authorize the invasion of privacy for public safety, public security, and oftentimes the meaning of these terms, public safety, public security, is not entirely clear and is often left to interpretation by government agencies and the courts. And in some ways, that is at the expense of people's privacy. International human rights law, however, attempts to challenge or to counteract surveillance by governments by requiring that any interference with an individual's right to privacy through surveillance has to be able to meet three tests. It has to be legal, that is, it has to be prescribed by law, must be sufficiently clearly written and justified under law, with sufficient safeguards for any invasion of such privacy. Second, that any interference to the right to privacy through surveillance has to pursue a legitimate aim. The aim can include the protection of national security and public order. However, that aim, thirdly, has to be met by imposing a necessary and proportional means of surveillance. This means that governments are required to ensure that the means employed by a measure that they want to impose provides the lowest degree of interference with the right to privacy, and that when balancing the nature and extent of such interference, the government should demonstrate that the harm does not outweigh the outcome. So in that sense, you could say there's a way in which privacy and surveillance can coexist if government surveillance is checked or policed by international human rights law frameworks that require specific tests are adhered to when governments are launching surveillance technologies or using surveillance practices.
To follow up on that, what would be, in your opinion, the most pressing issue to be addressed when it comes to state surveillance nowadays?
I think that there are numerous pressing issues on that need to be addressed when it comes to state surveillance nowadays. But I think one of the main ones is the expansion of global surveillance, or the expansion of the global surveillance industry as a result of countries that have geopolitical power, economic power. So European countries, the United States, China, exporting or promoting the export of surveillance infrastructures and laws and policies to facilitate surveillance capacities across the world without adequate safeguards. So this export of technologies that promote surveillance capacities creates a great deal of risks to fundamental freedoms and rights. And for example, Amnesty has in various reports highlighted how, for example, in its automated poverty and discrimination report on the Serbian welfare state, highlighted ways in which the World Bank, for example, has funded and established the social card registry, which encourages surveillance practices by the Serbian government when they are trying to make decisions on social benefit distribution. And so I think the export of technologies by countries that have geopolitical power, economic power, to other countries around the world without ensuring that there are adequate safeguards is one of the main issues or pressing issues that need to be addressed in the surveillance discussions.
Now, you have mentioned technologies a couple of times now, and this could bring us to another hot topic nowadays, just to make things a bit more complicated for you. Where, in your opinion, does AI fit into all of this when it comes to government surveillance? What are the challenges that AI could pose in that regard?
Thank you for the question. So we are seeing, especially in my line of work, we're seeing governments increasingly using algorithmic decision-making systems, which are designed to analyze a wide range of personal and sensitive data for surveillance purposes. And governments are using these systems to identify patterns of unusual or suspicious behavior for the purposes of detecting welfare and tax fraud, and to make predictions or to trigger risk alerts in policing. The use of these data-driven systems by governments raises concerns about their impact, not only on people's privacy, freedom of expression, freedom of movement, but also concerns about how these systems encourage discrimination against marginalized groups, and how these systems also, or the use of these systems, negatively impacts people's economic and social rights. So for example, in 2021, Amnesty International, in its Xenophobic Machines report on the Dutch government's use of the Siri algorithm, highlighted how the Dutch tax authorities' use of nationality data to assess whether benefit applicants were committing fraud resulted in discrimination against people with non-Dutch nationalities in general and ethnic minorities, and how the use of nationality data allowed for racial profiling of these groups. The report also highlighted how, for example, as a result of the use of the Siri algorithm, parents and caregivers who are wrongly accused of fraud experienced numerous violations to their economic and social rights. Some of them experienced devastating financial problems because they had increased debt and could not access social benefits and had to pay back large sums of money to the authorities. Others were forcefully evicted in their homes, from their homes, because they were not able to meet their mortgage and rent payments. Others suffered mental health issues because of being wrongly accused of fraud. So you get to see that AI is basically becoming a common reality in surveillance infrastructures, and governments are constantly taking up AI use to provide governance, provide public services, benefits, tax services, etc.
Thank you very much, Helen. Now, let's perhaps expand our views and concentrate a bit on the developments outside of the European Union. Now, we see a fast growth of data protection laws also in African countries. And I'm mentioning this because one of the focuses of your work was also the development of data protection law in Kenya. So how would you describe this development? What were or what are still the main challenges, and is there an influence of the EU data protection framework to the development of data protection in Kenya or more generally in Africa? We have already heard that Kenya and European Union have recently announced the start of an adequacy dialogue to explore the possibility of building a safe personal data bridge between the two economies. We don't need to mention this would be the first time an adequacy decision would be issued for a state of an African.
Thank you. Thank you for your question. Yes, Kenya had for years not had a comprehensive data protection framework, although the right to privacy was guaranteed under Article 31 of the Kenyan Constitution 2010. In 2019, however, after years of lack of a comprehensive data protection framework, the Kenyan government enacted the Kenya Data Protection Act on the 25th of November 2019. And the act has a strong influence, or the GDPR has a strong influence in the act. The drafting of the Data Protection Act of Kenya was led by the Data Protection Task Force at the Kenyan Ministry of Information and Technology. And the task force relied on several frameworks as reference documents as it drafted the Data Protection Act. The GDPR was one of the frameworks. The OECD Principles on Data Protection was another framework, the Asia Pacific Economic Cooperation Privacy Framework, and data protection frameworks of Mauritius, South Africa, India, and a data protection bill of Uganda at the time. Uganda now has a data protection act. So the drafters of the Data Protection Act relied on these frameworks, and the aim of using these frameworks as reference documents was to find out how data was regulated elsewhere and to adopt provisions that were suitable for Kenya. The GDPR influences are very much depicted in the Data Protection Act. For example, the core principle on data protection and data processing and lawful processing of data are included in the Data Protection Act under sections 25 and 39 of the Data Protection Act, similar to those provisions contained in Article 5 and 6 of the GDPR. The Data Protection Act also has provisions on the appointment of data protection officers, similar to the provisions in the GDPR. The Data Protection Act of Kenya also has provisions on data protection impact assessments, again, similar to the provisions in the GDPR. However, although the Kenya Data Protection Act is substantially modeled on the GDPR, and there are similarities with the GDPR, it contains some nuances that reflect the contextual background within which the act was enacted. And this is reflected, for example, in Section 37 of the Data Protection Act that contains provisions that restrict commercial use of data, including restrictions on the use of personal data for direct marketing, unless a data subject has provided explicit consent. And this provision does not exist in the GDPR specifically because the GDPR does not make a distinction between sharing of data for commercial or non-commercial purposes, but it exists in the Kenya Data Protection Act because of attempts by Kenyan regulators to address concerns in the Kenyan context that relate to data fraud and unlawful sale of personal data by corporations and individuals without people's knowledge. So you see some nuances in the Data Protection Act of Kenya, while at the same time we see the impact of the GDPR in the crafting of the provisions of the Act. With regard to the adequacy requirement or adequacy dialogue that encourages a transfer of data between Kenya and EU countries, I think that recent agreement shows or is a demonstration of the Brussels effect or the extraterritorial nature of the EU data protection standards beyond EU countries to non-EU countries such as Kenya. And you also see how a dialogue such as this can facilitate trade interactions and partnerships between Kenya and the EU. And it also, the adequacy dialogue provision also raises, in my view, tensions or highlights some tensions between this whole idea that we need to gather as much data as possible and transfer data and use data on the one hand, which may be regarded as a challenge to privacy. So we see that as being raised by this adequacy requirement. But then we also see concerns about privacy on the other hand because of the opening up of a personal data bridge. So the tensions that emerge from this adequacy dialogue bridge and the tensions actually that emerge throughout the GDPR, for example, and even the Kenya data protection are pretty apparent in this regard.
Thank you very much. Now we are reaching, I would say, the end of our time for this discussion, but perhaps one final question. Now we have traveled a bit around the world. I will try to travel a bit in time now and look into the future. So we know and agree privacy and human rights go hand in hand, but by being both positive and a skeptic. How do you envisage our society and our democracies in 20 years?
Thank you. I think that with technological advances and the increased use of technologies by governments and corporations, and also increasingly non-governmental organizations and individuals, ensuring the rights to privacy are upheld will involve quite a lot of work in the next 20 years. I think that ensuring the right to privacy is adequately protected will need to include a revisiting and a reformulating of data protection frameworks to find a way to center rights of individuals and groups more. Going back to the point I was making about data protection frameworks are important because they center individual privacy rights, but then they also create some tension by also encouraging data gathering, data sharing, data use. So I think as years develop, as time passes, there will need to be a reassessment and probably a reevaluation of data protection frameworks as privacy protecting frameworks to find out whether they still provide adequate regulation over government power and over the power of technology companies in the data space.
And this brings us to the end of today's episode. We have discussed various perspectives on data privacy topics, and Hellen has shed light not just on the hot topics heavily debated in the EU, expressing a lot of concerns about the AI and its use and the need for safeguards, but also on what is going on outside of the EU bubble. We are happy to see that data protection seeds are taking roots also outside of the EU. It was an honor having you here today, Hellen. Thank you very much.
Thank you very much for having me.
And dear audience, we hope these insights give you a fresh perspective on privacy and data protection. And if you enjoyed this episode, don't also forget to catch up on previous interviews and to follow DDPS on our channels to discover more about our projects marking the 20th anniversary of the European Data Protection Supervisor. My name is Nikša Stolic, and this was the talk with Hellen Mukiri-Smith from Amnesty International. See you in the next talk.